The first thing Linda Falk ever said to me was not hello. It was not who are you. It was, get your truck off this road or I'm calling the sheriff. I'd been up since 5. Hadn't eaten. I was driving out to check the east fence line. Completely normal Tuesday morning, and there she was, standing in the middle of the road with a clipboard, while a guy behind her bolted a chain between 2 concrete posts that definitely weren't there yesterday. I stopped the truck. Got out. What is this? She walked over like she was doing me a favor. This entrance is now private. HOA residents only. I actually looked around, the way you do when you think you've taken a wrong turn. I hadn't. This was the same road I had been driving since I was 14 years old, sitting on my grandpa's lap, steering while he worked the pedals. Ridgeline Estates Homeowners Association. I'm Linda Falk, board president. And you are? Emmett Hale. I own this land. She didn't even blink. Just looked at me like I'd told her I was the president of Mars. No, sir, you don't. This road is part of the HOA common area. Has been since 2014. If you have questions, you can submit them in writing to the board. Submit them in writing. To a board. About my own road. I should have said something sharp. I should have gotten out and shown her the deed right there. But I didn't have it on me. And honestly, I was just confused, the specific, disorienting confusion of someone who has just had the furniture in their own living room rearranged while they were asleep. So I just sat there, engine running, looking at this woman who had poured concrete into my grandfather's road and was now telling me to file a complaint. Ma'am, my family has owned this property since 1958. That's nice. But the HOA was established in 2014, and this land was incorporated. You're welcome to verify that with the county. So I did. Right there in the truck. Pulled up my phone, went to the county assessor website, typed in the parcel number. I know it by heart because my grandpa made me memorize it when I was a kid. The man was like that. The map came up. I zoomed out. And I sat there staring at my phone for probably 30 seconds. Because every single one of those 47 houses back there, every driveway, every lot, every inch of that little neighborhood was on my land. All 2,300 acres, still deeded to my family. Still in my name. I looked up. Linda was already walking away. Done with me. I put the truck in reverse. Didn't say a word. Just drove home the long way. I needed to find some paperwork. My name is Emmett Hale. I'm a land surveyor. 26 years. That's the one thing you need to know about me to understand why this story went the way it did. I read land records the way most people read text messages. It's just what I do. The property, the 2,300 acres, came from my grandpa Roy Hale. He bought it in 1958. Paid cash. Well, mostly cash and a trade involving a tractor and some timber rights, but that's a whole other story. He owned it free and clear. No mortgage, no liens, nothing. Growing up, it was just open land. Hills, creek beds, oak trees, hay fields on the south side. Grandpa ran cattle on it for a while, then stopped when his knees gave out. When he died in 2007, he left everything directly to me, not my dad, who'd moved to Phoenix in the 90s and wanted nothing to do with the land. Clean will, no disputes. I kept paying the taxes. Kept the fences up where I could. Drove out every couple of weeks to check on things. But I was living 20 minutes east, closer to town. I always came in from the south, checked my fence line, walked the creek, and drove home. I never went up to the north end because there was nothing up there. Or so I thought. Around 2012, a developer named Gene Massey had started building on what he believed was land he owned. By 2014, there were 30-some houses. By 2019, 47. Full neighborhood, streets, sidewalks, a clubhouse with a pool. HOA established. Elections held. Rules made. The whole time, every bit of it, they were building on my land. The tax bills didn't change because the county was still assessing it as undeveloped agricultural land. Nobody notified me of any rezoning. Nobody asked for an easement. Nobody knocked on my door. Gene Massey just built a neighborhood on my property. And apparently nobody checked whose name was actually on the deed. That night I drove out to my grandpa's farmhouse, still mine, still locked up, nobody living in it. His office in the back is exactly how he left it. Wood desk, filing cabinet, A calendar on the wall from 2006. Smells like old paper and dust. The kind of room where time stopped and stayed stopped. Grandpa kept everything. Every receipt, every letter, every handshake deal he ever made, he wrote it down and filed it. The man didn't trust banks, didn't trust lawyers, and definitely didn't trust anyone who said don't worry about the paperwork. It took me about an hour to find the box. Brown cardboard, taped shut, sitting under 3 other boxes at the bottom of the closet. I pulled it out and set it on the desk. Inside was everything. The original deed from 1958. The survey map, hand-drawn, but accurate. I checked it against the county plat. Tax receipts going back decades. Correspondence with the county about grazing rights. A letter from some developer in 1987 who'd wanted to buy the North Ridge. Grandpa had written NO across it in red marker and filed it anyway. And then the will. Clean, simple, notarized. Everything to Emmett Roy Hale. That's me. I spread it all out on the desk and looked at it. 60+ years of ownership, documented, unbroken, clear as day. Then I pulled up the county records on my laptop. And this is where being a surveyor matters. Most people look at a county plat and see shapes. I see parcel lines, easement corridors, right-of-way designations. I can read a legal description the way a mechanic reads an engine code. Gene Massey's development had been platted in 2012. The plat referenced a deed that supposedly transferred the north section of my property to a company called Ridgeline Development LLC, which Massey owned. But when I looked for that deed in the county recorder's office chain of title, it wasn't there. There was a reference number. When I searched it, nothing came up. No transfer. No sale. No easement. Gene Massey had somehow gotten a subdivision plat approved for land he never legally acquired. I closed the laptop. Sat there in my grandpa's chair, in my grandpa's office, surrounded by my grandpa's paperwork. 47 families had bought homes on land that was stolen from me. And Linda Falk was running the place like she owned it. Next morning, I drove straight to the county recorder's office. I know the people there. When you're a surveyor, you're in that office twice a month minimum. Brenda at the front desk knows my coffee order. Morning, Emmett. What are you looking for today? Full chain of title on parcel 114-027 and the original plat filing for Ridgeline Estates. She didn't ask why. That's one thing I like about Brenda. She just pulled it up. It took about 40 minutes. And the more I read, the worse it got. In 2011, Gene Massey had filed a quitclaim deed on the north section of my property. For people who don't know, a quitclaim deed is basically a document that says I transfer whatever interest I have in this property to someone else. The key word is whatever interest. If you have 0 interest, you're transferring 0. It's not a guarantee of ownership. It's just a piece of paper. Gene Massey had 0 interest in my land. He owned nothing. But he filed the quitclaim anyway, transferring property from one shell company he owned to another shell company he also owned. He essentially sold the land to himself. Land he never bought. Land he had no right to. The county recorded it. Nobody checked. Nobody compared it against the existing deed. They just stamped it, filed it, and moved on. That quitclaim became the basis for the entire subdivision plat. The plat got approved. Streets got built. Utilities got connected. Houses went up. Families moved in. All on a document that was worth less than the paper it was printed on. Brenda brought me a coffee without being asked. I think she could tell something was wrong. I sat in my truck in the parking lot for a long time afterward. Not thinking about Linda anymore. Not thinking about the chain across my road. Thinking about Gene Massey, a man I had never met who had stolen 2,300 acres from my family while I was out fixing fence posts. 47 houses. Average sale price in that area, maybe $350,000, maybe $400,000 each. I kept running the math in my head. Somewhere around $17–18 million worth of real estate sitting on my land. And somebody had made that money. Not me. I needed a lawyer. I called 3 lawyers before I found one who didn't think I was crazy. First guy told me the ship had probably sailed. I might get compensation, but I wasn't getting that land back. I hung up. Second one told me my lack of diligence could work against me, like it was my fault someone forged a deed. Third call was a man named Warren Actley. Small office on the south side of town, right next to a barbecue place. I'd done some survey work for him years back on a boundary dispute. Old school, quiet, the kind of lawyer who reads everything twice and doesn't say much until he's ready. I told him the whole thing. He didn't interrupt once. When I finished, he was quiet for about 10 seconds. Bring me everything you've got, every document. Tomorrow morning. So I did. Warren spread it all out on his conference table, really just a big folding table with a tablecloth, and went through it page by page. The original deed, the survey, the tax records, Grandpa's will, the quitclaim deed Massey had filed, the plat, 43 pages from the recorder's office, all of it. He went through every single page. Took him almost 2 hours. I sat there drinking bad coffee from a styrofoam cup and didn't say a word. Finally he looked up, took off his glasses, rubbed his eyes. Emmett, this is fraud. Plain and simple. Gene Massey filed a quitclaim deed on property he had no legal interest in. He used that fraudulent deed to get a subdivision plat approved. Then he built and sold 47 homes on land he never owned. So what do? First thing, we file a quiet title action. That's a lawsuit asking the court to confirm who actually owns this land. Based on what I'm seeing here, that's you. Your chain of title is clean. Massey's is not. His entire claim rests on a worthless quitclaim deed from a company that had nothing to transfer. And the houses? He leaned back. That's the complicated part. 47 families bought those homes in good faith. They didn't know Massey didn't own the land. They're victims too. But legally, the land is yours. You can't build a valid title on a fraudulent foundation. I nodded. I wasn't trying to kick anybody out of their house. That was never the plan. But I also wasn't going to let someone steal my family's land and then tell me I couldn't drive on my own road. File it, I said. Warren picked up his pen. This is going to get ugly, Emmett. You know that, right? It's already ugly. I just didn't know it yet. Warren filed the quiet title action on a Tuesday. By Thursday, my phone was ringing. Not from a lawyer, not from the court, from Linda Falk. I don't know how she got my number. Actually, I do. It's a small county, everybody knows everybody's cousin. But the speed of it surprised me. 2 days. That's how fast word travels when you mess with someone's HOA. I let it ring twice. Third time I picked up. Mr. Hale, this is Linda Falk. We need to talk about this lawsuit you filed. What you're doing is reckless and irresponsible. You're threatening the homes of 47 families. These people have mortgages. They have children. You're going to drag them into court over some old piece of paper. Some old piece of paper. She called my grandfather's deed, a legal document recorded in 1958, some old piece of paper. I stayed calm. Wasn't easy, but I did it. Linda, I'm not trying to take anyone's home. But that land is mine. It's been mine since 2007 and it was my grandfather's before that. Someone built a neighborhood on it without permission and I have a right to address that. Gene Massey bought that land legally. We've seen the documents. You've seen a quitclaim deed that transferred nothing. Massey never owned the land. The deed he filed was from a company he created to another company he also created. There was no actual purchase. No actual sale. I have 60 years of unbroken title. He has a piece of paper he wrote to himself. Silence for about 5 seconds, which is a long time on a phone call when someone's angry. We'll fight this, Mr. Hale. The HOA has resources. We have legal counsel and we will protect our community. That's your right. She hung up. Part of me felt bad. Not for Linda. She'd been nothing but dismissive since the moment I met her. But for the families. The people who'd saved for years, gone through inspections, signed mountains of closing documents, moved in thinking they owned something. They did own the house. They just didn't own the ground under it. That was a different story. And it wasn't their fault. It was Gene Massey's fault. And maybe the county's fault for not catching it. But it was definitely not mine. 2 days later, a letter arrived. Official HOA letterhead. A fine. $250 for unauthorized vehicle on HOA property. My truck. On my road. On my land. I put the letter on the kitchen table and actually laughed. First time I'd laughed in a week. The fines didn't stop. Over the next 3 weeks I got 4 more. Unauthorized vehicle, $250. Failure to maintain property appearance, $300. Unapproved structure on HOA land, $500. That last one was about Grandpa's farmhouse. A building that's been standing since 1954. And my personal favorite, livestock violation, because 2 of my neighbor Dale's cows had wandered through the fence again and someone in Ridgeline Estates had spotted them near the walking trail and called Linda. Total fines, $1,300. For existing on my own land. Warren told me not to pay any of them. They have no authority over you. You're not a member of their HOA. You never signed their covenants. Every one of those letters is evidence for us. So I kept them. Filed them in a folder. Dated each one. But here's the thing about getting fined for things that make no sense, it wears on you. Even when you know you're right. Even when your lawyer says ignore it. You come home and there's an envelope in your mailbox with your name on it, telling you you've done something wrong. Again and again and again. It's not the money. It's the feeling. Like someone keeps poking you in the chest saying you don't belong here, this isn't yours, who do you think you are? And then the gossip started. A guy at the hardware store asking if I was that guy trying to steal those people's houses. A woman at the gas station giving me a look and turning away. A note left on my truck at the grocery store. Leave Ridgeline alone. Someone on that board was talking. And the story going around town wasn't a man's land was stolen by a developer. The story was some greedy guy is suing families to take their homes. That hurt. I'm not going to pretend it didn't. I called Warren. They're turning the town against me. I know. I've heard. Ignore it. Easy for you to say. No, it's not. I go to the same barber as half these people. But Emmett, the court doesn't care about gossip. The court cares about deeds. And yours is solid. He was right. Knowing something and feeling it are 2 different things. I started driving to the hardware store in the next town over. Took my groceries from there too. Extra 30 minutes each way, but I didn't have to deal with the looks. I was being pushed out of my own community over land that was mine. And the woman doing the pushing was sitting in a clubhouse on my property, running board meetings about how to get rid of me. About a month after the lawsuit was filed, I was out on the south end checking the fence line. Truck parked, tools in the back, just doing my thing, and I noticed tire tracks. Fresh ones. Not mine. Someone had been driving on the back roads of my property, the old service trails Grandpa had cut through the timber years ago. I followed them. About 1.5 miles in, I found survey stakes. Orange flags on thin metal rods, pushed into the ground in a straight line running east to west. Someone was surveying my land without my permission. I pulled one out and looked at it. No markings, no company name. Just orange plastic flapping in the wind. I drove the rest of the trail and found 12 more, all in a line, heading straight toward the back edge of Ridgeline Estates. I called Warren. Someone's surveying my property without my permission. Don't touch anything else. Take photos of everything. GPS the locations if you can. Already on it. Surveyor. Remember? I spent the rest of the afternoon documenting every stake, tagging GPS coordinates, mapping the whole line. It ran from the county road on the east side straight through to the back of the subdivision, like someone was planning a new road. When I showed Warren the next day, he leaned back in his chair. They're trying to establish an alternative access route. If they can show they have another way in and out, it weakens your leverage on the entrance road. Can they do that? Not legally. Not without your permission or an easement. They don't have either. He paused. This is Linda Falk thinking she's smarter than the law. I found out later through county records, not gossip, that the HOA had hired a surveying company from 2 counties over. Paid them in cash. No permit filed. No notification to the landowner, which is required by state law. They were trying to build a case that there was an existing access road through my property that the public had been using for years. Prescriptive easement. The legal theory that if people use a road across your land openly and continuously for long enough, they can sometimes claim the right to keep using it. Problem was nobody had been using those trails. Nobody except me. Those trails didn't go anywhere except deeper into my timber. There were no tire tracks before this month because there was no reason for anyone to drive back there. They weren't documenting existing use. They were manufacturing it. And I had the GPS data to prove it. I started keeping a log after that. Dates, times, anything that happened on or near my property. Bought trail cameras, the kind hunters use, and strapped them to trees along the access roads and the main entrance. Motion activated, time-stamped. Within 2 weeks, I had plenty. The surveying crew came back 3 more times. Always early morning, from the East Side County Road. 2 guys in a white pickup, no company logo. They drive in, place more stakes, take measurements, and leave. Never knocked on my door. Never asked permission. The cameras caught all of it. Every visit, license plates, faces, timestamps. But that wasn't the worst part. The worst part was what started happening at the entrance road. Linda had upgraded the chain situation. The concrete posts now had a proper metal gate with a keypad. HOA residents got the code. I didn't. Not that I needed a code to access my own land. But the message was clear. You're out. We're in. She'd put up a sign too, big, green, white letters. Ridgeline Estates. Private community. No trespassing. Violators will be prosecuted. On my land. With my name on the deed. A no trespassing sign telling me I'd be prosecuted. I took a photo of that sign standing right next to it. Sent it to Warren. He responded with 1 word. Perfect. Then things got personal. One morning I found a notice taped to the gate of Grandpa's farmhouse. Not mailed, taped. Someone had walked onto the property, up to the house, and stuck a paper on the gate. It was a formal HOA notice stating that the structure was in violation of community aesthetic standards and needed to be brought into compliance or removed within 60 days. They wanted me to tear down my grandfather's house. I read it twice. Folded it up. Added it to the file. That same week my property tax bill arrived. Something was different. The assessment had jumped, not a little, a lot. My 2,300 acres had been agricultural land for decades. Low tax rate, normal for rural property that isn't developed. But someone had filed a request with the county to reclassify a portion of my land as residential. And the county, without notifying me, had adjusted the assessment. My annual tax bill went from about $4,000 to over $31,000. I sat at my kitchen table staring at that number. $31,000. For land I wasn't developing. Land I wasn't building on. Land that someone else had built on without my permission. They were trying to make it too expensive for me to keep my own property. I'm not going to pretend that tax bill didn't scare me. I'm a surveyor. I do fine. I'm not rich. I drive a 12-year-old truck and my biggest luxury is buying good coffee beans instead of the store brand. $31,000 a year would eat me alive within a few years. And I think that was exactly the point. Warren told me he'd seen this tactic before. You can't beat someone in court, so you bleed them financially until they give up or settle for nothing. He filed a formal protest with the county assessor. His argument, my land was never rezoned. Nobody applied for a rezoning permit. The county changed the assessment based on what was physically sitting on the land, the houses. But those houses weren't my development. I didn't build them. I didn't approve them. I didn't profit from them. He told me to pay my usual amount and attach his letter. So I wrote a check for $4,000 and change, same as always, and mailed it in. That month was hard. I won't sugarcoat it. I'd drive out to the property and see those houses up on the ridge, lights in the windows, kids riding bikes on streets paved over my grandfather's pasture, and I'd think, how does this happen? How does a man work his whole life, buy land, pay for it, maintain it, pass it down to his grandson, and then some guy with a fake deed just takes it? I started questioning myself. Maybe I should have walked the whole property every month. Maybe if I'd caught it in 2012 when Massey first filed that quitclaim, none of this would have happened. Warren shut that down fast. This isn't your fault. You're not required to patrol your own land against fraud. That's what the county recorder's office is supposed to catch. That's what title companies are supposed to catch. They all failed. Not you. He was right. But knowing something and feeling it are 2 different things. Around this time I found Gene Massey. I'd been looking for him since this whole thing started. The man who filed the fake deed, built the subdivision, sold 47 houses, and disappeared. Warren had been trying to locate him. He was a named defendant, but the address on his LLC filings was a P.O. box that had been closed. His company had been dissolved in 2020. No forwarding address, no phone number. But here's the thing about being a surveyor. I spent half my life in county records. I know how to find people through property. And people who steal land in one place usually buy land somewhere else with the money. It took me 3 weekends. I searched deed transfers in every surrounding county, checked LLC filings with the state, cross-referenced names. And I found him. Gene Massey had purchased a 160-acre ranch 4 counties over. Nice place. Paid cash in 2016, right around the time he would have finished selling the last of the Ridgeline houses. He'd used a different LLC name, but the registered agent was the same. His wife. I gave the information to Warren. He got quiet the way he always does when something clicks. I'm going to subpoena his financial records. Every bank account tied to Ridgeline Development, every sale, every closing. I want to see where $17 million went. Can you get that with what we have? The quiet title action gives us standing. And the fact that he dissolved the company and moved to a ranch he paid cash for, that's going to look very interesting to a judge. In September, 1 month before the hearing, something else happened. A younger Ridgeline resident named Chris called me. Said he'd been watching the whole situation play out and felt uncomfortable with how the board was handling it. He didn't give me specifics. He just said, they're planning something. You should be ready. 2 days later, the HOA filed a counter-suit against me, claiming I was engaged in fraudulent property claims, harassment of community residents, and intentional interference with property values. They wanted $2 million in damages. $2 million. From me. The man whose land they were sitting on. Warren wasn't worried. It's a pressure tactic. They're trying to bury you in legal costs so you'll settle. The claim has no merit. You cannot harass someone by asserting legal ownership of your own property. So we keep going. We keep going. And Emmett, I've got the subpoena for Massey's financials approved. Once we see where that money went, this case is going to crack wide open. But I hadn't found the most important document yet. I'd been going through more of Grandpa's files on weekends, box by box, sitting in his office, making sure I hadn't missed anything. In a box I hadn't opened yet, behind a stack of old cattle receipts, I found a folder labeled Simply Road. Inside was a document I had never seen before. A road maintenance agreement from 1963. My grandfather had made an arrangement with the county. He would maintain the main access road, and in exchange the county would grade it once a year with their equipment. The agreement specifically identified the road as a private road on private property maintained by the landowner. There was a map attached, hand-drawn, but with measurements, showing the road starting from the county highway, running north through the property, ending at what was then the old timber line. That's exactly where Ridgeline Estate's main entrance is now. The county had signed it. Grandpa had signed it. It had been recorded with the county clerk. I called Warren and read him the whole thing over the phone. He was quiet for a moment. Emmett, that document is gold. But we already know I own the road. Because one of the arguments the HOA is going to make is that the road was always a public or shared use road and the community has a right to use it regardless of who owns the land. This document proves the opposite. The county itself acknowledged in 1963 that this road is private. They signed an agreement with your grandfather specifically calling it a private road on private property. That kills their prescriptive easement argument before they even make it. I looked at the document again. Grandpa's handwriting at the bottom. Roy Hale. Same handwriting that was on my birthday cards when I was a kid. The man had been protecting this land even from the grave. There's something else, I said. The map shows the road ending at the timberline. That's exactly where the Ridgeline entrance is now. Which means they didn't just build on my land. They built their entire entrance, their main access, their gate, their sign, all of it on what was always a private road. Right. So hypothetically, if I wanted to, I could sell that road. Or close it. Warren paused. Hypothetically, that road is your property. You can do whatever you want with it. I set the folder down. Sat there for a while. I wasn't thinking about revenge. Not exactly. I was thinking about leverage. October 14th. Courtroom B. I wore a button-down shirt and clean boots. Warren wore the same gray suit I'd seen him wear to every hearing since I'd known him. Linda Falk was already there, front row, behind her attorney, a man in an expensive suit who looked like he'd rather be anywhere else. 3 board members flanked her, arms crossed like they were at a PTA meeting, and I was the problem parent. Gene Massey was not there. His attorney was a young guy who looked like he'd graduated law school about 15 minutes ago. He filed a motion to delay. Judge denied it. The hearing started. Warren went first. He laid it out, simple, clean. The chain of title from 1958. Continuous tax payments. The original deed, the will, the 1963 road maintenance agreement. He put every document on the overhead projector one at a time, slowly, letting the judge read each one. Then he showed the quitclaim deed Gene Massey had filed. Walked the judge through it step by step. Shell company to shell company. No purchase agreement, no closing documents, no title search, no money exchanged. Just a piece of paper that said I hereby transfer this property to myself. Judge Caldwell, 20 years on the bench, stopped Warren at that point. Counselor, are you telling me the entire Ridgeline Estate subdivision was built on land acquired through this single quitclaim deed? Yes, Your Honor. And there's no underlying purchase agreement, no bill of sale, no evidence of a legitimate transaction? None, Your Honor. We've searched the county recorder's office, state corporation records, and Mr. Massey's available financial records. There is no evidence that Mr. Massey or any entity he controlled ever legally acquired this property. Judge Caldwell looked at the quitclaim deed on the screen for a long time. Then she looked at Massey's attorney. Counselor, does your client dispute any of this? The young lawyer looked like he wanted to disappear. Your Honor, my client maintains that the quitclaim deed was executed in good faith. In good faith, he transferred property from a company he owned to another company he owned. He had no prior interest in this land. How is that good faith? Silence. My client is prepared to discuss a resolution, Your Honor. I'm sure he is. I looked at Warren. He didn't look back. He was watching the judge. But I could see the corner of his mouth, not quite a smile, but close. Then Linda's attorney tried the adverse possession argument. Said the residents had been living there openly, paying taxes, maintaining the property. Said they'd built lives there. Said it would be unjust to uproot an entire community. Judge Caldwell let him talk. Then she asked one question. How long has this subdivision existed? Since 2012, Your Honor. And the statutory period for adverse possession in this state is? He hesitated. 15 years, Your Honor. So your clients are approximately 3 years short. Is that correct? Your Honor, we would argue that the equitable. I asked a simple question, Counselor. Yes, Your Honor. Technically they are short of the statutory period. Then the adverse possession claim fails. Move on. He moved on. Tried to argue prescriptive easement for the entrance road. Said residents had been using it continuously since the subdivision was built. Warren stood up. Your Honor, I'd like to enter into evidence a road maintenance agreement from 1963, recorded with the county clerk, in which the county explicitly acknowledged this road as a private road on private property maintained by the landowner, Mr. Hale's grandfather. The document went up on the screen. The whole courtroom went quiet while Judge Caldwell read it. Counselor, she said to Linda's attorney, this road was designated as private 60 years ago. Your clients had been using it since 2012. That's not a prescriptive easement. That's trespassing. I looked over at Linda. She was whispering to one of her board members. Her face was red, not embarrassed red. Angry red. The kind of red that means someone still believes they're right and can't believe the world isn't cooperating. Her attorney tried one more thing, the countersuit. The $2 million claim for harassment and property value interference. Judge Caldwell looked at him with an expression I will not forget. Let me understand. Your clients are living on land they don't own, using a road that belongs to someone else, and they're suing the actual landowner for harassment because he filed a lawsuit to reclaim his property. Your Honor, the residents. I'm going to stop you there. This counterclaim is dismissed. With prejudice. With prejudice. Gone forever. Can't refile it. Done. Linda stood up in the gallery. Her attorney turned around and put his hand up. trying to get her to sit down. She didn't. Your Honor, those people have homes. They have families. You can't just... Ma'am. Sit down. I haven't issued my ruling yet. Linda sat down. Her hands were shaking. I could see them from across the room. Judge Caldwell looked at Warren. Then at me. I'm going to take a brief recess before ruling. 15 minutes. The longest 15 minutes of my life. I sat on a bench in the hallway with my hands on my knees, staring at the floor tile, counting the little squares in the pattern. Anything to keep my brain from spinning. Warren brought me a paper cup of water and sat down next to me. How are you feeling? Like I'm about to either win or lose everything my grandpa left me. You're not going to lose. You don't know that. He sat with that for a second. Then, Emmett, I've been doing this a long time. I know what a judge looks like when she's already made up her mind. Caldwell made up her mind about 20 minutes into that hearing. The bailiff opened the door. We went back in. Judge Caldwell sat down and didn't waste time. I've reviewed the evidence and the arguments presented by all parties. Here is my ruling. She paused. Looked at the courtroom. The quiet title action filed by Emmett Roy Hale is granted. The court finds that Mr. Hale holds clear, unbroken, and undisputed title to the property described as Parcel 114-027, comprising approximately 2,300 acres. The quitclaim deed filed by Gene Massey in 2011 is hereby declared null and void. It was executed without legal basis, without consideration, and without any legitimate chain of title. It is, in the court's view, a fraudulent instrument. I heard Linda make a sound behind me. Not a word. Just a sound, like the air going out of something. Furthermore, Judge Caldwell continued, the court finds that the Ridgeline Estates subdivision was platted, approved, and constructed on Mr. Hale's property without his knowledge or consent. The homeowners who purchased properties in this subdivision are victims of a fraud perpetrated by Gene Massey and his associated entities. This court strongly recommends that those homeowners pursue legal action against Mr. Massey and any title companies involved in the closings. She looked directly at Linda. As for the Ridgeline Estates Homeowners Association, the HOA has no legal authority over Mr. Hale's property. The fines, cease and desist orders, and other actions taken against Mr. Hale are null and void. Additionally, this court is referring the unauthorized survey activity and fence destruction documented by Mr. Hale to the district attorney's office for review. Warren put his hand on my arm. Didn't say anything. Just put his hand there. I couldn't speak. I just sat there and listened to a judge say out loud what I had known since I was 16 years old. This was my land. After the ruling, the courtroom emptied fast. Linda's board members left without a word to anyone. Her attorney packed his briefcase and walked out with his phone already against his ear. Linda stayed, sat in the front row by herself for a moment, staring straight ahead. Then she got up and left through the side door. I didn't say anything to her. Didn't need to. Warren and I stood outside on the courthouse steps. October's sun, warm despite the month. He shook my hand, first time he'd done that since the day I hired him. When out? I asked. Now the real work starts. He wasn't wrong. Over the next 2 months, a lot happened. Warren filed a civil suit against Gene Massey for fraud, conversion, and unjust enrichment. The subpoena on his financial records came through. Massey had made just over $16 million selling those 47 houses on my land. He'd used the money to pay off debts, buy the ranch, and fund 2 other developments in neighboring states, both of which were now being investigated. The district attorney opened a criminal investigation into the fraudulent quitclaim deed. Massey was charged with forgery, fraud, and filing a false instrument. Last I heard, he was fighting extradition from his ranch. It wasn't going well for him. The title companies that had handled the closings started getting sued by the homeowners, because that's whose job it was to catch this. When you buy a house, the title company is supposed to search the chain of title and verify it's clean. Every single one of those 47 closings should have flagged that quitclaim deed. None of them did. 47 title searches. 0 catches. The county reversed the reclassification on my land and refunded the tax difference. The planning department launched an internal review into how the subdivision plat got approved without verifying the underlying deed. Two people in that office quietly retired within 6 months. And Linda Falk resigned as HOA president. Didn't announce it. Didn't make a speech. Just stopped showing up. I heard she sold her house 3 months later and moved out of state. Couldn't get what she paid for it. Turns out property values drop when an entire neighborhood finds out it was built on stolen land. Here's what I did with the land itself. I could have kicked everyone out. Warren told me that legally, those houses were on my property and I had every right to demand they be removed, or charge retroactive rent, or make things difficult in 100 different ways. I didn't do any of that. I worked with Warren to set up long-term ground leases for all 47 homeowners. Fair price, below market actually. Enough to cover my property taxes and put a little aside. The families got to stay in their homes. They got legal security. They paid the lease to the person who actually owned the land. Most of them signed within a month. A few held out, hoping the title company lawsuits would make the whole thing go away. Eventually they all signed, because people with kids and mortgages don't like uncertainty. The entrance road, the one Linda had chained off that first morning, I kept it. It's mine. I took down her gate, pulled out the concrete posts, removed that green sign. Replaced them with a simple metal gate with a code. Gave the code to every resident, no charge, because that's what a normal person does. But I also recorded a proper easement this time, legal, documented, filed with the county. The road is mine. The residents have a right to use it. Nobody can ever chain it off again. Not me. Not them. Not some future board president with a clipboard and an attitude. I still drive out to the property every couple of weeks. Check the fence line, walk the creek. Same as always. Sometimes I drive past the subdivision and see the houses, kids playing, someone mowing the lawn, a guy washing his truck in the driveway. They're on my land. And that's fine, because we worked it out the way it should have been done from the beginning. With a conversation, a handshake, and a piece of paper that actually means something. Last week I was out at the farmhouse. Sat in Grandpa's chair in his office. The room that still smells like old paper and dust, the room where time stopped and stayed stopped. I opened the bottom drawer of his desk. Found a note I'd never noticed before. His handwriting. Just one line. Take care of the land, Emmett. It'll take care of you. I closed the drawer. Drove home the long way. Here's what I want you to take from this story before you go. This whole thing started because I wasn't paying attention to my own property. I was checking the south fence. I was fixing the east gate. And meanwhile, somebody built an entire neighborhood behind my back on the north end. The scary part is this actually happens. People file fraudulent documents, county offices miss things, title companies skip steps, and by the time you find out, someone is standing on your land telling you that you don't belong there. So here's the practical thing. Go pull up your deed. Right now, today. If you own land or property, go to your county assessor's website and look at it. Make sure everything matches. Make sure nobody has filed anything on your parcel that you didn't authorize. It takes 10 minutes. It costs nothing. And keep your paperwork. Grandpa kept everything for 60 years. That box in the bottom of the closet. Original deed, survey map, road maintenance agreement from 1963, that box won the case. Not money. Not connections. Not a high-priced attorney. A box of old paperwork in a closet. Know what you own. Know where it starts and where it ends. Because the people who want to take it from you are counting on you not knowing. If you've had something similar happen, an HOA overreach, a property dispute, a situation where someone tried to tell you that you didn't have a right to what was legally yours, I genuinely want to hear it. Drop it in the comments. I read them. Subscribe if you're new, because there's another story coming next week and I promise you it's just as wild as this one. Take care of the land. See you next time.